I'm Kayte Lewis from Voice Lawyers, and this is Voice in the Crowd, the podcast for people, not lawyers. It's about demystifying the law, speaking in plain English, and sharing practical insights into how the legal system really works in everyday life. Each episode draws on real stories and experiences, the good, the bad, and the confusing. If you feel overwhelmed or confused by the law, or you're just interested in our stories, this podcast is for you. Voice in the Crowd, where the law meets real people. Well, hello. Today we have special guest Professor Ian Coyle with me, and I'm very excited to have Ian with me. He is a forensic psychologist, and we are going to be talking about lying in court. So a few interesting facts and figures might get thrown around today. But first of all, Ian is a fellow of the College of Forensic Psychology of the Australian Psychological Society. He's an academic member of the College of Clinical Psychology of the Australian Psychological Society, an adjunct professor at the School of Psychology and Public Health and Law at La Trobe University, and also an adjunct professor at Thomas More Law School at the Australian Catholic University. So quite the CV, and I'm very excited to have Professor Coyle with us today to share some of his incredible insights and years of research. Hello, Ian. Thank you for joining me.
Pleasure to be here.
So you are a very well-published author.
Yes, I published a reasonable amount. Going back way back to 1975 when my doctoral thesis was floating around. And I was publishing in psychopharmacology, because my doctoral thesis was on prenatal drug effects on behaviour and brain development, and criminology, because at the same time as I was doing my PhD full-time, I was also publishing research in criminology and working out how you can measure bias in assessments in courts.
Right. So there are some very in-depth academic studies there, a bit more than what I've ever done.
Yeah, but I moved on. I moved into other areas, including human factors engineering. It's like matching the capabilities of the human to demands of the work and leisure environment. And I've obviously published.
So that's a really, really broad sweep of work that you've done.
Yeah, I get bored.
You get bored.
It's that simple. I get
bored too. I thought we'd start a podcast because I was getting bored. So
I'm still low boredom threshold, so there's something else.
So how about we start with, can you tell us, first of all, because our listeners are primarily lawyers, they are normal people. So what is forensic psychology and the connection between science and the law?
Forensic psychology is concerned with the interaction between psychology and the law. For example, whether someone has the capacity to work out where they want their estate to go if they die. That's called testamentary capacity, and there's an interesting article that I'll come back to on that later. Then you've got whether someone is fit to stand trial for, say, murder, or whether they had some mental condition that prevented them from knowing what they were doing was wrong, or prevented them from stopping what they were doing. They couldn't control their behaviour. Now, those tests vary from state to state in Australia, but that's broad enough to cover it. They didn't know what they were doing was wrong when they torture someone and chop their head off, for argument's sake, as happened recently in New South Wales, or whether they're just taking drugs.
So I don't know whether my introduction actually quite covered the types of reports that Professor Coyle has published, but a lot of them involve criminal law and at the very severe end of the criminal spectrum, aren't they?
Overwhelmingly, the work I get involved in is murder, attempted murder, or manslaughter, severe assault. There's a number of cases where I do get involved from the civil side of things, civil claims, with victims of child sexual abuse. I don't know anymore, but it's more than 900 court cases I've been involved in there. And that can interleave with people taking drugs to go through what happened to them and so on. So there's no brick wall between forensic and clinical psychology. The disciplines interleave, and so it does with the law.
So that's the role. The role then of expert reports in the law is to bring science into the law. Is that fair enough to say?
That's one way of looking at it. The other way is to assist the court, which includes jurors as well as judges, in evaluating the claims that have been made by the prosecution against the defendant and the arguments advanced by the defence against the prosecution's claims. It's there to provide objective, scientific, clinical information to assist the triers of fact, whether it's a judge alone or a jury.
Right. And I guess that moves us into what we're here to talk about today, which is the lying, perhaps, or how to know if somebody's lying.
Lying.
And
lying is a big ticket item in court cases.
people get quite upset when you come straight out and call them a liar. I mean, you do have to sometimes dress up those words a little bit, but maybe not in your case, but sometimes I have to.
Well, I might change it and say that the evidence given by the accused has no bearing in fact, which is a polite way of saying he's lying.
That's what I mean. That's a nice way of saying you're lying. There's lots of different ways of saying it.
Well, people could also be incorrect but not actually lie. They've misheard something or misseen something. And in fact, I was involved in a case in Brisbane last year that finished up with a hung jury, where the evidence was that there had been significant post-event contamination of people's memories by them all getting it together and talking about what they claimed to have seen while they were heavily drunk. They were all drunk and they'd also been smoking a lot of cannabis and probably other things. They all admitted they were off their trolleys. But then the squeaky wheel effect came in play. There's a predominant female who got everyone to agree that what she'd seen is what they'd seen.
Right.
Now, that seems, well, can that really happen? Can your memory be really affected that way? Yes, it can. It really can. And that was my evidence there, resulted in the trial being declared a mistrial. And I don't think they're going to try and start it all over.
And run it again. So just for people, so if there's an issue where it's a hung jury, perhaps, what happens then? It's over, and you have to start again.
Yeah, that's a matter for the court to decide, the prosecution. I've had a number of them where they've walked away from it, a number of them where they've continued on, come back for another trial. I had one in South Australia last year where a woman who was a victim of child sex abuse had entered what's called a fugue state. That's F-U-G-U-E. And
what is that?
Well, people who are victims of child sex abuse often usually develop post-traumatic stress disorder. One of the diagnostic criteria looked at is whether they have memories coming back that cause them to lose touch with reality. It's a fugue state. They're trying to, if you like, mentally run away from it. In this particular case in South Australia, the woman was decided she had to leave Adelaide. She's got this overwhelming sense of fear. So she gets in the car and she drives off because she's had a bit to drink. And she leaves out on the way outside Adelaide to overtake the truck and runs head on into a semi-trailer. And the police charged her with attempted murder of the semi-trailer driver. I kid you not. I'm not. You can't make this up. You really can't.
No, they're usually the most outrageous thing.
Well, in that particular case, after my report was served, was made available to the Crown prosecutor, not the police. The charges were dropped.
Okay.
She was in a psychotic state, a fugue state, that was a function of her child sexual abuse, full stop.
Right.
She had something to drink, but she was a little bit over the limit, but that wasn't the major cause. And the major cause is that she was running away from
just
the evil.
The memories that
the memories, but they'd become real again.
Okay. So I guess what you're saying then, if when we're trying to, not that I'm trying to decide anything in court, I'm not a judge, I'm not a jury, but when a judge or a jury are trying to decide whether somebody is lying in court, there are certain things that they tend to look at. And I think you have done quite a bit of work in this and published last year an article called The Pinocchio Index.
Yes, that was a trimmed down version of some major scientific research published in going back to 2014. That's how long I've been doing research in this area. So
Okay.
sort of past my apprenticeship.
Yes, it's a fair while. And this is something that we've discussed because I have a particular interest without the same depth of pedigree. But before I was a lawyer, I have always been a speech and drama teacher. And so my particular interest is in the psychology of voice, hence the name Voice Lawyers. I
wasn't aware of that. That's quite clever, actually. I like that.
Well, that's where it comes from. So for my passion for voice and understanding how it affects you and it affects your life. So I find this particularly fascinating because, obviously we want you to take us through, but is the overarching premise that you have found that it's your voice that's more likely to disclose whether you're lying rather than the physical body language that we've come to colloquialize?
In fact, it's what you actually say, not the way you say it, that is most important. The broadest we can use, the distinction we can use is verbal and non-verbal behaviour. Now, overwhelmingly, most people believe that non-verbal cues, whether you're moving your hands or whatever, are much more important than verbal cues in determining whether someone's lying. That's comprehensively and completely wrong. The most important cues for determining whether someone's lying are verbal. Now, there's been any number of studies. One of the classic ones go back to the Detection of Deception Research Group, who did a study on 75 countries around the world, all on the same, and they came up with a list of things that people said were indicative of someone lying. Although humans have spread across the globe, they speak different languages. In fact, there's people in this group, participants in this study, there are 45 different languages spoken. They have remarkably similar observations about what works and what doesn't work in detecting lying. Unfortunately, a lot of the time they're wrong.
Okay.
Now, let me give you an example. It's often assumed that if someone doesn't look him in the eye when they're answering your question, they're lying. That's not so. I'm going to read directly from the Queensland Equal Treatment Benchbook. Now, that's a benchbook is, I think, a book to assist lawyers in running a court case. And this is noted in the Equal Treatment Benchbook, the current one at page 54. A large part of the assessment of a witness's credit is based upon non-verbal forms of communication. The observation of a person's demeanour is an important tool in making this assessment. However, many aspects of behaviour and demeanour are conditioned by culture. Well, the problem is that non-verbal forms of communication are almost completely useless in determining whether someone's lying. I say almost. So there's a whole list that we can go through. And I'm going to read from the paper I published with the late emeritus Professor Donald Thompson. Now, Donald was a barrister as well as being a professor in psychology. Apart from Gay's version of other global pan-cultural stereotypes of lying include the entrenched beliefs that liars shift their posture and move around and ask a difficult question, touch and scratch themselves, and tell longer stories than usual, like politicians.
They're not lying?
None of these stereotypes are accurate.
Okay.
None of them are accurate. More generally, we know that being perfectly still is an indicator. Now, there's a list of things that have been identified and shown to work and not shown to work.
I have a list
Yeah.
or article
Well,
that liars make fewer movements with their hands, arms, and fingers
and feet, yeah.
and feet.
Mm.
And liars use fewer illustrations, illustrators like their hand movements.
Waving your hand. Look, he had a face this big. Right, I got to say. It's got a face that
So they
big.
tend to not do that. That's what you're saying.
Yes, they use fewer illustrators.
Okay. And liars take longer pauses.
Yes.
Is that because they're
thinking about what can I say?
Okay.
So
Liars,
if someone, the classic example there of the male comes home and his wife's put a new dress, what do you think of the dress? I like the colour.
liars give more indirect answers.
Yep.
Like that one. Okay.
Precisely.
A liar's stories contain fewer details.
Yes. Because it didn't happen. They haven't got any memory of what happened. They're trying to make it sound plausible. So that's also why they tend to give more indirect answers while they're trying to think of what to say. What did you really like about my dress? Apart from the colour. Well, there's no loose threads on it.
And liars make fewer spontaneous corrections.
Yes, because they've got into a spate of lying, so they don't want to admit they're wrong. Because after one of the classic studies on this came out when Kayte was finished, 2023, I think, from Aldert Brij, B-R-I-J, from the University of Portsmouth. Now, his entire, virtually most of his academic career, he's been around lying. And they did this brilliant sort of study. They got a real life courtroom with real life judges and barristers, court attendants, and they had real live potential jurors. They're called venire jurors. They're sitting around waiting for Gary to be picked up. And the only person who was not involved in the legal system one way or the other was the defendant, so-called, who was the person acting. And in one group, had to watch the person give evidence for the sake of this study, wearing a face mask because COVID was still around. The other group got to see the person without the face mask. Now, which group do you reckon were more accurate in detecting whether the person was lying? With the face mask or without the face mask?
Well, I would have thought it should be without the face mask.
You are wrong.
Right.
Everyone says that, but I've asked.
Well, because that's what you expect the answer to be.
See, the thing is, with the face mask on, they listened more carefully to what the person was saying. They weren't put off by him looking around or grimacing or whatever. They were concentrating on what he was saying. Now, the other thing that was interesting is that if people keep perfectly still when they're talking, when they're responding to a question, they're more likely to be lying because they're using all their mental energy on coming up with a good story. Now, and that's particularly the case with respect to the hands and feet. And you know what you can't see in a witness box?
You can't see much.
You can't see the hands, you can't see their feet, you can't see that they're still, you can't see if they're squirming or anything.
No.
So part of the problem we have here is the design of the courts, which was founded centuries ago on the notion that you could tell when people were
right,
or it was a mistake.
Well, they're terribly formal and off-putting places, courts, and often, obviously, as a lawyer and as a litigating lawyer, such as I am, I'm there quite a lot. But when you take a client in that hasn't been into a courtroom before, and obviously the civil courtrooms are different to the criminal courtrooms, they are very, very daunting. And I mean, I guess there's good reason for that. I mean, you are going into a court and it shouldn't be like going to the supermarket.
Yeah.
But I guess one of the things that's coming out of what you're saying is it actually designed for us to get to the truth? I mean, that's the whole point of court is to get to, isn't it? To get to the truth or to get to, a fair solution.
Well, from a jurisprudence perspective, lawyers would certainly say this is the best system we've got to try and get to the truth. But to then take the next step and say what we've got is perfect is just nonsense.
So is there anything you would do to change it?
Yes, I'd get rid of the witness box as it is and I could see them.
Right.
That'd be a good start. The other thing that I would say is that, and there's nothing to stop barristers doing this now, to bring in expert witnesses who can say, look, this is what really works and this is what doesn't work, to try and get rid of people's preconceptions that can negatively influence their behaviour, by which I mean make them more prone to make mistakes. That will be resisted with ferocity by the legal profession. They said, but we've been doing it this way for a couple of 100 years. Well, so what?
Well, change doesn't come quickly,
Well,
does it?
I've given expert evidence in a number of cases like this, particularly criminal matters, but it's just as valid.
So what about, obviously, you know that we do family law, and I know that's certainly not your favourite area. But, you know, say in a family law situation where we're trying to figure out, or the court's trying to figure out whether, you know, somebody is alienating a child from the other parent, or whether this, you know, the allegation that's been made about abuse is actually happening, or, you know, what you know, people go into these situations, they've never been in court before, they've never had to do this type of thing before. And some people seem to come out of it looking better than others.
Well, yes, but that doesn't mean that even if you're very well versed in the law, you're going to come out of it well. But even in family court, I know that's in a number of cases where I've had to provide assistance to lawyers who go through that, the ringer in that jurisdiction. I don't want to go too far down that line, because I realise it's a very difficult jurisdiction, and it's I think the courts try their best, those in charge, of course, to deal with it in the most efficient, and some of those matters are just truly evil to try and get involved in. It's the next thing. Whatever you do, we're going to be pillories.
Yes. Well, I mean, there is certain, I know my background in performing, and I worked as a theatre director for many years, so I'll sometimes run clients through just some skills just to try and keep them calm so they answer sensibly. Is that useful? Does that
Well, of course,
help with the lying, or does that help cover up things? What's
the overarching thing, of course, is the person who's speaking is the one who's either telling the truth deliberately or not telling the truth deliberately. And there's only so far that any barrister can go down that path. They've got to make that decision themselves. In terms of providing information to the jury or the judge, if it's a judge of a trial, to enable them to contemplate that at the basis of science as to whether the person is lying or not, that's appropriate for an expert to give evidence. And there's a lot of research in it. And it, as I've said, it goes against the common sense view of things, which is maybe common, but it's not sensible. It's just simply wrong.
Yeah. So I guess that's something to be very mindful of. And so you're saying that having an expert come and have some input into that can be useful.
Yes, well, let's look at let's go back to the study by Professor Reed. That's classic study. Because the jurors, the mock jurors in that case, when they didn't have the face mask on, they would look at the person and get seduced, by the way. When they just listened to the facts, they were more accurate.
So you're saying it's word choice then?
No, it's the way in which the information, and there's a number of elements of that. They're all listed in various things. For example, let's go through a number of big ticket items. Liars tend to speak in a higher pitch relative to baseline performance. So when they're being cross-examined, their pitch goes up. It's a lie. Liars take longer pauses. So on the 27th of February, 2023, you were driving your car. Is that correct?
Yes. What day is it?
I picked an example because no one knows what they're doing. On the 27th of February last year, but in court cases, they haven't have to go back.
I know, it's crazy.
Someone's got to refresh their memory. Liars' answers are less plausible. So you're saying that on the 27th of February, 2020, the reason that you swerved was because an alien spaceship had landed in the middle of the highway.
Yes.
Yeah. We'd say that's probably less plausible.
Yeah,
Right?
that's plausible. Okay.
Lawyers' stories contain fewer details.
Lawyers or lies?
Lies.
Oh, be careful. We don't want to interchange those two.
That's called a Freudian slip there, actually. Liars give more indirect answers. Liars' stories contain less temporal, perceptual, and spatial information. So where did the assailant come from? He came out of the door in the leading to the toilet. And how far away was the door from where you were sitting? And was there any chairs between or tables between the toilet and the chair you were sitting at? They're the sort of things that should be asked through. And liars make fewer spontaneous corrections. That's a big ticket item. Liars will tell a story, stick to it like, breakfast or a blanket. I was going to say something else, but we'll leave it there.
Yeah. We don't want to have to put any disclaimers up.
No. So those are facts.
So I want to go on to something else then. I know we've talked a lot about criminal law, but I seem to be stuck on this track at the moment. In criminal law, they tend to use two different things. One is like a pretext call, which is a call that is set up to have by the police, to have somebody call you and ask you questions and try and basically catch you out. Now, for the life of me, I can't understand why that's not entrapment. This is why I don't do criminal law. And secondly, evidence, once it goes to court, is usually transcribed from these calls. And there's no nuances in a transcribed call.
Let's go back to the first item on this list I have here. And that's referred to in the paper I published called Opening Up a Can of Worms. How the decision makers decide when witnesses are telling the truth. Liars tend to speak in a higher pitch relative to baseline performance. You can't pick that up from the transcript.
No.
Liars take longer pauses. You can't pick that up from the transcript. So they're just two. Liars make fewer spontaneous corrections. I might have said, but two big ticket items there you can't pick up.
But that's an interesting one too, where you're saying they may have said and that would indicate that they're telling the truth. And I would often see that would be taken as, look, they're making it up, in exactly the opposite way.
And that's where expert evidence comes in. Look, I don't know how many research articles have been published in this area, but it's easy enough to determine. You go on to Google Scholar, anyone can get it, and you type in lying in court cases or what works in detecting deception, and you hit the button, and bing. Let me give you an example of how broad those things can be. If you type in something related to that, say, just off the top of my head, child sexual abuse and, in capitals, brain damage, and acts as a mathematical thing that you've got both phrases there together. It's called a Boolean operator, if you want to get excited about it. That leads, how many research articles do you think you're going to find? Try 413,000 if you type in child sexual abuse and psychopathology as of today.
So there's a lot of research on this, and what you're saying, what I'm trying to take away is that how well do you think this is integrated into our court system with finding whether people are lying or not lying, given there's so much research?
I don't think it's particularly well integrated at all. I think what's needed is for certainly some of the bar books to be rewritten.
Well, that example
Queensland
is inconsistent.
I think it's inconsistent with the science. It is inconsistent with the science. Full stop. And a lot of these legal precedents and arguments are entrenched. And we go back to, for example, 1870 Banks v. Goodfellow. And Mr. Goodfellow, I think, or Mr. Banks, I forget which one, was a paranoid schizophrenic. He thought that the ghost of his long dead neighbour was sodomising him every night. And the question was, when he died, whether the will that he authored with the argument lawyer was valid. Well, the court said, yeah, it doesn't really matter that he was named as a March Hare, because he understood what his estate was, who he could make a claim on it, and how he could apportion. And that's actually quite a good rest from a psychologist's perspective, because you don't have this in delebo, you may or not met. People can have a range of psychopathology, but perfectly capable of doing other things. So actually, you've got to look at each case by itself. But the notion that judges and barristers, based on precedents from years ago, often a century ago, can determine what's scientific evidence, what's the court should rely upon, allow jurors to consider now, without keeping abreast of scientific advances, is just completely without any significant virtue.
Well, that's a big call, isn't it? But what about our jurors? I mean, there's moves in some jurisdictions to get rid of jury trials. What do you think of that?
Well, it depends what sort of case you've got to go. Sometimes a trial before a judge alone has distinct advantages. I'm confining myself purely to a forensic psychological perspective.
Yes.
In fact, I've got a case that I won't go into details because it's still sub judice before the court, where there's great argument as to whether the defendant diagnosis was correct or not correct. Now, that's a matter where I think the judge is far better in a far better position than jurors to deal with, because particularly the Supreme Court Justice, as is the case in this matter, has had to consider psychological and psychiatric evidence in criminal matters over decades. So they have some knowledge of what's going on that the average juror probably wouldn't. The average juror, if you ask them what's forensic psychology about, would probably look at you and say, what?
They don't know. Yeah. So I mean, we are in an interesting dilemma.
Well, yeah, but look, in some cases, my personal view is that a trial by judge alone that is to be preferred is more likely to lead to a reasonable and outcome. In other cases, I think it's better for a jury to be involved. But I'm just one voice there. That's just my opinion. And ultimately, what's needed is a proper interaction between science and the law. That's the big ticket item. That's the one that gets me all more than undercover.
I can see that. Look, thank you very much for coming and spending this time talking with me today. We didn't even get to touch on all of the workplace material that you do. So maybe that's for another day.
I'm more than happy to do that, because sometimes that leads to extraordinary findings.
Yes. So
I've got one at the moment that you honestly won't believe.
Well, let's save that one, and we'll come back and we'll talk about that. But people can get in touch with you, Professor Coyle, can't they? But it's probably their barrister or lawyer that would be best to get in touch with you if they need a forensic report.
Well, I think it's always best to go for a forensic report. Then that should be going through a solicitor.
Mm-hmm.
But sometimes I'll speak have a chat to people that are facing. I'm not here to advise them on which lawyer to go to. I'm not a one-stop shop in that regard. And I think they'd be better off to talk to their lawyer about contacting me. But for the sake of a simple response about what do I think about ABC, well, I can be found on the internet. Just type in my name and you'll find I come up.
Wow. Thank you very much.
Pleasure.
Just before you leave, I have a quick but important note. What we've discussed in this podcast is general information only. It's not legal advice, and it's not a substitute for getting advice tailored to your specific situation. The law, and family law and employment law particularly, are highly fact-specific. Small details can make a big difference. So if something we talked about resonates with you, we encourage you to get proper advice before taking any action. Nothing in this podcast creates a lawyer-client relationship, but we're always happy to point you in the right direction. If there is something you'd like us to discuss, please reach out and let us know, and I hope you tune in next time.